Suzman Foundation launching a fresh court challenge asking for the reasons why former President Jacob Zuma was placed on medical parole. The foundation says what Correctional Services head Arthur Fraser did was unlawful and his decision should be set aside. Zuma was released on the 5th of September, 58 days after he was incarcerated at the Ascot Correctional Facility. For more on this, we joined by the Foundation's legal researcher, Chris Fisher. Chris, thank you so much for making time. Just explain to us what your application entails. Are you reviewing that decision and challenging it, or are you merely, for now, asking for the reasons that the decision was taken?
Hi, Clement. We're doing both. So in the first instance, we are asking that the Commissioner be compelled to release the decision, his reasons, and any supporting documents that go along with that. That's to facilitate a review that will test the lawfulness of his decision, to test whether he made that decision on the basis of the right information and within the powers that the legislation involved gives him.
As it stands now, what do you understand to be the powers that he has as Commissioner and what the limitations are? Because my understanding is that the Act does give him the power to take the decision as long as it's rational. So the person has to be terminally ill, they have to be incapacitated. So as long as he can justify that and there be rationality on the decision, he's got the power to do that. But in this case, you've got the Independent Medical Advisory Board that has advised him otherwise. What do you understand about the powers he has and the relationship between whatever decision he takes and the recommendations by this Independent Advisory Board?
Well, the independence of the advisory board is actually key to the answer to your question. So the decision to place an offender on medical parole does lie with the Commissioner, but it is a decision composed of various requirements or various considerations. And one of those is a medical consideration. And our argument is that for the medical aspect of that decision, you need the expertise of the Medical Parole Advisory Board to rise to a fundamental, to play a fundamental role in authorizing the decision. For the aspects of the decision that are related to correctional services matters, there Mr. Fraser's discretion is perhaps a little bit more broad and a little bit more concentrated in his person. But for the medical judgment, we believe that the legislation doesn't empower him to override. But you are correct about the rationality point. If there is room in the Act for him to make a decision contrary to the board, it must be rational. It must be based on some sort of reasonable or some sort of rationale for departing from the board's decision. And that's why the reasons are so critical. That's why we need to see the record of that decision to determine whether his departure was made rationally.
Yeah, how difficult do you think that's going to be? Because there are issues around privacy and how much you can disclose of someone's ailment. Do you think that's going to be a deterrent?
I think that will be a stumbling block. It certainly will be something that Mr. Zuma will want to raise in his defense, for lack of a better phrase. The Helen Suzman Foundation has raised that in its papers, and it's very open to Mr. Zuma to make a case for privacy of his medical records to the extent that privacy is genuine and doesn't override the legitimate transparency or interest in transparency that the public has. But most importantly, there are mechanisms there are confidentiality regimes that can defend Mr. Zuma's privacy, even in the context of a review. For example, where the information is kept strictly between the parties to the litigation. And I think that there is definitely room in that regard to balance Mr. Zuma's privacy rights or privacy interests and the interests in the public of having this decision reviewed in a transparent manner.
Yeah. Just lastly, as we wrap up, I was looking at the reasons why Section 79 of the Act was actually amended a couple of years ago. And the reason for that was so that you ensure that the legislation could not be manipulated into granting this parole on medical grounds to any prisoner who is not deserving of it. So one of the things I don't understand is, what is really the point of having this independent advisory board if, as commissioner, you've got the power then to decide willy-nilly whether you take their recommendation or not? Because the very reason of having that independent advisory board is so that you don't abuse the process. But in this manner, and in this case, even if they recommend this or the other, as commissioner, according to the Act, you can simply decide, I'm ignoring that advice. But once again, as you've indicated, it must be based on rationality. I'm just asking because I'm thinking, why establish this and amend the Act to try and avoid abuses when this independent advisory board is not going to have much powers, really?
Well, I think you've raised the point very well, Clement, is that if we're going to read the Act to give any sort of meaningful purpose to the Medical Parole Advisory Board, we will have to give its determination some special or some fundamental role in the decision for medical parole itself. Mm. The commissioner is, absent that independent check, clearly open to abuse. The exercise of his power is clearly open to abuse without that independent check. So that's why our arguments are pressing quite fundamentally that point, that in order for this process to have any kind of independence and be free from political abuse, the Medical Parole Board must play a fundamental role in the decision, at least in the medical aspect of that decision.
Yeah, absolutely, because that's why they are independent, and that's why you established this when you were making the amendment to the Act. Thank you so much for making time. Chris Fisher is the legal researcher at the Helen Suzman Foundation.